in that fashion.
That's acceptable, Your Honor, to the respondent.
Great, thank you.
I'm just getting the live stream started. Just so
Okay. All right, great, thanks. So I'll pause just for a moment till we have that up and going.
I'm on my sound.
It looks like it's going.
Great, thank you, Mr. Cooper.
Yeah.
Okay, so the plan for this morning is to hear closing arguments from each of the parties, and I just want to touch base with each of the parties as to a general time estimate of how long you think your closings will take. I'll look first to Mr. Taylor.
I think around 20 minutes, Your Honor.
Okay, all right, thank you. And Ms. Bremner, a time estimate?
Similar time, maybe 30, Your Honor.
Okay, very good.
Is that about right?
Yeah, that sounds great. Thank you. If there's no other preliminary issues to address, we could go ahead and begin with closing arguments. I'll first see with Mr. Taylor and then Ms. Bremer if there's any additional items that need to be addressed prior to closing.
Thank you, Your Honor.
Thanks, Your Honor. Members of the commission, I said yesterday morning this was a simple case. It still is. Judge Ruzumna displayed incredibly bad judgment in taking what he called the two heavy lifters, the court stamp and Judge Robertson's stamp, in an effort to get something he thought he was entitled to. In his mind, apparently, the end justifies the means. In doing so, he betrayed the trust and responsibility required of a judge. But there's something more serious in this case, even more serious. And it needs to be addressed. And it's whether Judge Ruzumna has been honest over the course of these proceedings. Has he been honest with you? I want to talk about several things this morning. First, what do we require of a judge and why? Second, did Judge Ruzumna violate the Code of Judicial Conduct? That's an easy one. Does it matter whether pro tem judges are entitled to the discount? Take it as true. It doesn't matter, and I'll tell you why. Has the judge acknowledged what occurred? The answer is yes, but, and I'll explain what I mean. I want to talk about the effect of the misconduct on the respect for and integrity of the judiciary. And then I'm going to talk about something that's uncomfortable. Was Judge Ruzumna honest with you? Go through the evidence that bears on that. Then I'm going to touch briefly on the notions of sympathy and where and how that plays into this case. And finally, I want to talk about what the right outcome should be. Let me start with what do we demand of judges and why? The Ritchie case from the Washington Supreme Court teaches us that we require scrupulous standards of personal integrity. That's what we require of judges. As an aside, Ann and I tried the Ritchie case in front of the commission against each other 30 years ago. I have nothing but respect for Ann's abilities. There's another word in the code that bears on today, and that's probity. If you look at the definition of integrity in the code, you find the word probity. What does that mean? It means strong moral principles, honesty, and decency. What do we demand of judges, and what does the code demand of judges? Simple bedrock principles that we all know and appreciate. Why? Why do we require this? Well, because every day judges make decisions that can impact people for the rest of their lives in ways big and small. And it's at the district court level where most people who interact with the judiciary find themselves. And the system only works if people believe that they're going to have a judge whose morals, honesty, and integrity are beyond reproach. The robe means something. It's not something you use to try to save $10. Now to the easy part. Did the judge violate the code? Well, after insisting for the past 2 years that he used, or past year, that he used multiple stamps in random order in a farce, he finally told us yesterday that he used the 2 court stamps, the heavy lifters, in his words, not mine, the heavy lifters to get a discount. And he did it without permission. That clearly violates 1.3 of the code. He used the prestige of the judicial office, the stamps, to advance his personal interests. And in fact, if you look at the comment to 1.3, it says you can't use judicial letterhead to gain an advantage. That's what he did. He put the stamp, the judicial letterhead, on the document to gain a personal advantage. So did he violate the code? Yeah, no question about that. We heard a lot yesterday, particularly from Judge Hirakawa, about whether pro tem judges are employees and whether they're entitled to discounts. Well, that really doesn't matter. Let's assume he's right about the policy. Let's assume the pro tem judges are entitled to a discount. That's really just an argument that the end justified the means. That doesn't change what he did, and it doesn't lessen the gravity of what occurred. If anything, it makes it worse. I'm not getting what I'm entitled to, so I'll do whatever I have to do to get it. That's not what we want in a judge. It's not what the public wants in a judge. It's not what the public deserves. Has the judge acknowledged that the acts occurred? That's a yes, but he has displayed no understanding, no acknowledgement of the seriousness of what he did. He never once acknowledged the abuse of the trust placed in him by Judge Robertson. He was allowed to sit in her chambers, and he took advantage of it. If he really took to heart what he had done, if he embraced it, acknowledged it, what would he have done? He would have self-reported. Instead of acknowledging it, he was upset. He was upset because the weasel was going to report him. When you think about whether he's acknowledged whether the acts occurred, I want to direct you to Exhibit 313, a series of text messages between Judge Ruzumna and Judge Hirakawa. If we could have that pulled up, please. Go to the second page, please. This is Judge Ruzumna in blue, texting with Judge Hirakawa. Sorry to bug you on a Saturday. I need to know who's on the executive committee. Can you please let me know? Thanks. Judge Hirakawa, no problem. It's the great weasel, Matt York, Ms. Harn, Ms. Toole, Todd, etc. And then he says, what's up? And let's take a look at acknowledgement of responsibility. Let's take a look at how Judge Ruzumna responded. Can we have that next text, please? I got a nutty letter from the weasel, misconstruing everything. Misconstruing everything. Is that acceptance of responsibility? No. It's saying I did nothing wrong. He offered a name clearing hearing with him and someone from the EC if I want. So I didn't know who was on the EC. And what do we see? We see the seeds of his defense planted by Judge Hirakawa over a year ago. Just remember, KCDC, King County District Court, considers you an employee. And as an employer, KCDC failed to provide adequate support for employee entitled discount parking. What do we see then below that? Acknowledgement of responsibility? Just the opposite. I appreciate that, Greg. Exclamation point. Let's go further. Judge Hirakawa says, the only I would have any confidence in on the EC is Rebecca. And then we get the seal of approval stamp from Judge Ruzumna. Acceptance of responsibility. Matt York filed a bar complaint against me. So he wants me to lose my livelihood, my ability to support my wife and kids. What's going on here? Judge Hirakawa, let's go to the next block. These are texts that they never thought would surface, never thought they'd see the light of day. Well, the dickless little weasel will deny it if it's still a confidential proceeding. Goes on, has the bar asked you to respond? They dismissed it summarily for that reason. It's not in the bar's jurisdiction. Then he goes on to say acceptance of responsibility, but it still bothers me that he's pursuing this. He'll probably file with the CJC now. Acceptance of responsibility. Judge Hirakawa then fires back. I would file a complaint with the CJC against Judge York. Acceptance of responsibility. Yesterday, Judge Ruzumna would not even acknowledge, he wouldn't own the fact that he was referring to the chief judge as the weasel. He said, oh, I was just copying what Judge Hirakawa had said. He wouldn't even own that small fact. Change gears on you. The effect the misconduct had upon the respect for and integrity of the judiciary, one of the bedrock principles of the code. You heard Judge Robertson, you heard Judge O'Toole. Their reactions were genuine and heartfelt. Betrayal was the word Judge Robertson used, and it fits perfectly. Judge Ruzumna betrayed Judge Robertson, and he betrayed the system. Why did they express this emotion or those emotions yesterday? Because they understand that judges must be beyond reproach. Here's another easier way to think perhaps of the effect of this on respect for and integrity of the judiciary. If you were a litigant, if you were a mom, a dad, or a son, or a daughter appearing in front of Judge Ruzumna, and you had heard the evidence that you all heard yesterday, would you trust him to make for you what might be the most important decision in your life? Would you trust him to make the right?
Yeah, I object, and that's not even within his jurisdiction in terms of the types of cases he hears, and it's not based on the evidence. I object.
The objection's noted, it's argument.
Thank you, Your Honor.
Would you trust him to make the right call in a bail decision? Would you trust him to make any decision that's going to affect someone's life? If you knew you were appearing in front of him and you had heard the evidence that you heard yesterday, you wouldn't want him making your decision. You wouldn't trust him to make the decision. And you shouldn't be required to trust him. I said earlier, we're going to talk about an uncomfortable subject. And that's whether Judge Ruzumna has been honest throughout this proceeding. We have to discuss it because it bears directly on whether he cooperated with the investigation. And here are some things to consider as you measure and weigh and assess his credibility. First, you heard Ms. De Los Santos. She wanted a record of the document in case there was an issue. Given that, it would make no sense for her to omit a portion of the document, which according to Judge Ruzumna had a series of random stamps all over it. It would make no sense for her to take only a portion of the picture. We've all seen a notary stamp. If there was a notary stamp on the bottom of the document, it would have jumped off the page. And remember, he says not only a notary stamp, but his home address stamp, his Judge Pro Tem stamp, this stamp, the other stamp. Does it make sense that Ms. De Los Santos missed all of those? Something else about the stamps. We got his description yesterday of their size. He even drew a little diagram for us. Why didn't we see the stamps themselves? Why didn't we see examples of them? It would have taken 10 seconds to put a series of those stamps on a page and offer it as a demonstrative exhibit. Judge Ruzumna is represented by smart, experienced, talented lawyers. There's a reason you didn't see such a demonstrative. And here's why. Here's what that demonstrative would have looked like.
I object. This is not in evidence.
It's a demonstrative, Your Honor, for argument purposes.
Your Honor, I object. Demonstrative.
I'll sustain. I'll sustain. It should be
Thank
taken.
you.
Very well. We can all picture in our mind exactly what this document would have looked like if, as Judge Ruzumna says, it was covered with random stamps. Something else to consider as you assess and weigh Judge Ruzumna's credibility. His story has not been consistent. At the start of this case, farcical document with multiple random stamps. Let's look at Exhibit 202, page 3, line 5. We can highlight line 5, please. And blow that up. In other words, respondent created what he intended to be a farcical document adorned with multiple random stamps. That story, though, has morphed over time. And yesterday we heard for the first time, not a farcical document adorned with multiple random stamps, but that he intentionally used, in his words, the heavy lifters to boost the authenticity of the document, a document that he once said was a farcical document. Why did he do that? Because by the time the hearing came around yesterday, he realized he could no longer sell the story, farcical document adorned with multiple stamps. When you assess credibility, you have to ask yourself, has he been consistent throughout? The answer is no. Sympathy. In the first half hour of Judge Ruzumna's testimony yesterday, we heard a lot about his family and their accomplishments. I'm sure it's all true. And I'm sure this has been very hard on him and very hard on his family. And I don't mean to demean that in any way. But it has no place in this proceeding. It has no place in determining what the appropriate outcome is in this case. No place. What's the right discipline? What's the outcome in this case? I'm a trial lawyer. I make my living in the trial courts. I've won cases and I've lost cases. The only thing I ask for is an honest judge that I can respect. That's a different way of saying integrity of the judiciary. That's all any lawyer wants. That's all anybody appearing in a courtroom wants. If we can't guarantee the public that kind of a judge, bad things are going to happen. If you conclude that Judge Ruzumna has been less than honest, I submit he should be barred from serving in the future as a judge. In all of this, you're not writing on a clean slate. The King County District Court Executive Committee determined he was no longer fit to serve. Snohomish County suspended him for many months. You folks have to make your own judgment. But that doesn't mean you have to be blind to what other similarly situated bodies have determined. Ladies and gentlemen, thank you for your time.
Thank you, Mr. Taylor. All right, we'll turn our attention to Ms. Bremner for closing on behalf of respondent.
Thank you. It may please the court, the presiding judge, and members of the commission and opposing counsel. As I said in opening statement, and of course, to my client, Judge Ruzumna, that this case has really gone from the sublime to the ridiculous. You know, I kept thinking of that line from someone pretty famous here in Seattle, who's no longer with us, from Nirvana, Kurt Cobain. What else can I be? All apologies. He has been apologizing, cooperating, dealing with this forever. No, he was not thrown out of King County by the committee. In fact, he resigned before anything was done. In Snohomish County, I'm just going to start where he ended, because it's completely wrong, speaking of credibility, wrong information that's just been put before you by counsel, is that at that time when he went to Snohomish County, they did conduct an investigation and they brought him back. So they found that he was fit to serve after a full investigation. And another thing, King County never had a full investigation. Zero. The only investigation was a brief conversation. So let's look at something else I talked about in opening statement. I don't know what the name of that game would be today, but the game of telegraph or telephone or whatever it is, when one person says something, whispers in someone's ear, then it goes to the next person, and the next person. And at the end of the day, that last person, whatever they say, the statement was, that statement bears no resemblance to the initial statement. And that's a lot of what is in this case. Let's look at it on the facts of this particular case. Judge Robertson, she didn't know anything about the case. In fact, she didn't even talk to Judge Ruzumna. He wasn't allowed to talk to her. So all she sees is a partial piece of paper that shows her name, and she's offended. You know, like, oh, why did he use that? She's essentially told that he used her name and her stamp. And so she has a reaction that you might expect, like, well, I didn't okay that, and I thought he was my friend. And that's it. How about Ms. De Los Santos? All she has is a piece of paper from a parking attendant who's not here. The best witness would have been the parking attendant who talked to our client and can tell and corroborate what our client said, which was, this was all a joke, farcical, as he said. And he's credible because he's telling the truth. He always has been. Now, all she knows is that he tells her that I got this document. I'm going to come back to her testimony, but I'm just speaking to how certain people in this case were given certain information, limited, and reached certain conclusions. What about Judge O'Toole? She didn't talk to Judge Ruzumna. She didn't know anything either. All she did was have a committee meeting, and she saw part of a document. Again, just a piece of a paper, partial in terms of what he is. So, and then it goes on and on and on, this case, until this hearing. And the judge has been always cooperative. He's met with the commission. He's met with Reiko Kallner. He's met with Kurt Twitty. He spent hours with them. He's gone through this entire hearing. He has cooperative. He's talked about, and I'll talk about this in a minute. He's admitted part of this didn't look, exactly great. I mean, how much more does he have to do? I mean, he said he is sorry. He said it here in his testimony. He feels terrible about what happened. But let's turn to what the case really is about. First, counsel just said he lied. Where did he lie? Where? I mean, you can call someone a liar, but the question is whether or not you can prove it by clear, cogent, and convincing evidence. He's said from the beginning that you can't have it both ways, that either it was a joke or he was entitled as an employee to the discount, but both can't be true. Well, of course they can be true, because that's what happened. It was a joke, and he was entitled to the discount. That's the only basis you've heard from counsel to say that our client is a liar. That's a big, big charge against somebody, anybody, a lawyer, a judge, anybody in the justice system, to call them a liar without any basis. But that's what you've heard here. And I have respect for Mr. Taylor. We go way back to the Ritchie case. I don't remember if it was 30 years ago or 35 years ago, but the fact of the matter is, if you're going to call somebody a liar, you better have evidence that they're a liar. And there's none. There's a dearth of evidence that he's a liar. The prestige of the, let me go through in terms of what has been claimed here in the allegations and what's been argued to you on the statement of charges. First of all, when we're dealing with claimed fraud, I mean, this is a claim of fraud, and it's in our trial brief, but it bears repeating. You know, fraud has 9 elements, and this is under 1.3, all of which have to be proved, and that is, on common law fraud, a representation of an existing fact, its materiality, its falsity, the speaker's knowledge of its falsity or ignorance of its truth, his intent that it should be acted upon by the person to whom it's made, and then ignorance of the falsity on the part of the person to whom it's made. Let's stop there. That's number 6. He was a pro tem judge. He is a pro tem judge. And he was entitled to the parking discount. And he worked for King County. We know from Judge Hiwakawa that he clearly worked for the county. We know from the exhibits in his W-2 that he worked for the county. We know from the judge himself that he worked for the county. We know that other witnesses, the CJC witnesses or disciplinary counsel's witnesses, they weren't clear on whether he worked for the county. That's not clear and convincing evidence. Nobody said affirmatively he does not work for the county. And where else would he work? Snohomish County? Thurston County? I mean, he works for King County. So going back to the elements, that was number 6. That basically he gave false information, that the ignorance of the falsity on the part of the person to whom it's made, the attendant, the latter's reliance on the truth of the representation, and his right to rely upon it, and consequent damage. Not one of those elements is proved here. And that's what's been charged by counsel, disciplinary counsel. Not one of those things on 1.3. And then we take a look at, and I think it's subtle, but huge in this case. If the parking attendant did not believe, he was a judge, or if Ms. De Los Santos didn't believe he was a judge, that's something different. But the fact of the matter is, they're just saying you need to show that you're entitled to this discount in order to get the discount. I mean, that's what the case is about. Rule 1.1, a judge shall comply with the law, including the code. And he's done that. And then with respect to 1.3 on any kind of allegation of fraud, he's denied that he violated that, because rightfully so. His denial is appropriate. He didn't violate the rule. He was not attempting to prove he was a judge. It was for all King County employees. And I think that's the subtlety. He's not trying to say I'm a judge. He's saying I work for King County. And he wasn't using the office as a judge to get an advantage he was entitled to. A, he was entitled to it, but B, this is not a case that would be contemplated by that rule, which would be, you don't know who I am, do you? Or I'm a judge, I shouldn't get that parking ticket. Or I'm a judge, I shouldn't get that speeding ticket. Or I'm a judge, I should be treated in a certain way. And that's not what has been charged in this case. He didn't use the office of judge, something up there, of judge in some way to gain some kind of advantage. So was it a joke? Well, yes, that's what the evidence all supports. He had an ongoing conversation, I guess you could call it, with the parking attendant saying, here's my rope. I can show you that I work for the county. Here's my placard. He showed that. It showed his name and Judge Pro Tem. Those things weren't enough. He showed a W-2 that we've seen in evidence that he worked for the county. That wasn't enough. And so what he said was, you know, look what I made for you. Like he's laughing. Look what I made for you. And let's take a look at what the document is and what it is. And if we could put it back up, Karina, please. 203. It's a 201, excuse me. And it's, you know, don't you, and I think the members of the commission, don't you think that if anybody had saved this whole document, that we wouldn't be here today? Or, you know, what if we had the whole thing? We wouldn't be here today. I mean, the judge has not only been pilloried in the media in these proceedings, called a liar by Mr. Taylor when he's not, got live comments on YouTube, and going through these whole public proceedings, gone through an investigation in Snohomish County, gone through apparently one without his knowledge in King County, and then of course a bar complaint. Okay, let's take a look at it again. Where's the rest of it? Commission counsel has the burden of proof by clear and convincing evidence in this case. Where's the rest of the document? Where did it go? We've argued, of course, that it wasn't authentic and should be in evidence anyway, but we know it's partial. We know it doesn't include everything that was in stamps, and we know it's folded up just like the judge said it was folded up as he went to the parking garage to show it to the parking attendant. So, you know, where's the rest of it? And why didn't they keep it? And why was a picture taken that was only partial the document? Again, it's their burden of proof. They don't even have the evidence, the real evidence, the authentic evidence, and the evidence that would actually show our client's innocence. And I think that's really troubling. We don't even know what steps were taken to try and find it. We were told that it was given back to the attendant, or the attendant gave it back to somebody. We don't have it. We assume that the counselor would have a ability at least to reach out to find it and to find the attendant. So let's take a look at this and whether or not this looked official. Well, to Ms. De Los Santos, she thought it didn't. You know, what do you want to call that? That it's not a real document. I mean, she said that. So she didn't think it was. Then how can we think it is? I say we, the royal we, the commission, and the presiding judge. I mean, how can it be looked to be as something that's authentic when it's not? I mean, it clearly isn't. It clearly isn't. And the fact is, she wanted to show it to somebody else, basically to say, look, I don't think he's entitled, but take a look at this. You know, take a look at this document. But that's all it is. The remaining stamps, we heard a lot here in this case, going back to this claim that our client's a liar, but there's no evidence that he's a liar. That these other stamps that he had couldn't fit on this form if it was 8.5 by 11? The answer is they clearly could. And we showed you that when he basically drew out the size of his stamps. Counsel says we should have had a demonstrative evidence with the stamps. Why? We don't have any burden of proof in this case. We showed you how big they are, and we showed how they clearly could be on this document. Okay, we can take it down. Thanks. Did he use the prestige of his office in any appropriate way under 1.3? The answer is no. The attendant didn't even believe that he was a judge or worked for the county, apparently. So how could he have used the prestige of the office? On this, you know, what we kept hearing over and over again was liar, liar, liar. No evidence that he's a liar. And then we heard the weasel over and over and over again, that he used the word weasel. Well, we already heard in the evidence, the true evidence shows that he was repeating what Judge Hirokawa had called Judge York a weasel. I mean, I think we have all said embarrassing things in emails and texts before. or called somebody that we weren't crazy about, a name like a weasel, does that make him guilty of some kind of impropriety? The answer is no. But the fact that it was emphasized so much tells you how weak this commission counsel's case is, disciplinary counsel. Coming back to it again and again and again. He said the word weasel. It wasn't even his term for Judge York. It was somebody else's. Again, I think that just demonstrates that there is no case and there's a dearth of evidence, especially a dearth of evidence that he's a quote unquote liar. And I can say in my many years of practice, 40, I don't think I've ever called someone a liar. And I've seen a lot of liars, especially as a prosecutor. If you're going to call somebody a liar, you better have evidence. If you're going to call a judge a liar, you better really have evidence. And there's no evidence here that he's a liar. All right, the name clearing hearing, what happened in King County. Again, that's just an attempt to paint him in some negative light. He resigned. He saw, he took responsibility right away. Isn't that what we want with judges? Even though he didn't do anything that violated the canons, especially 1.3, he acknowledged back then and with the commission early on that some of this, and he acknowledged in our trial brief, that he didn't go about this the right way. He acknowledged that creating a farce, and I'm quoting from our brief and also our answer, a farcical document using any court stamps was not the right way to go about things. He's acknowledged that a long time ago. He acknowledged that the document he provided, stripped of all context, could be interpreted as being something other than a farcical document that he intended. But as we stated in our brief, when the commission hears all the evidence which you have, you should see, and I think you have seen, the context in which it was created. You were just asked about, or it was just asserted to you, would you trust this judge, our client, with any major decision? I think you would. He's clearly a thoughtful, smart, dedicated, empathetic, and remorseful judge. That's what we ask for in judges. He's exemplary. This whole two heavy lifters, I think that again is like the weasel comment, the liar comment, and then we see the heavy lifters. He didn't say these are heavy lifters as if he was trying to pull a fast one with a quote unquote document to anybody. I think that again was a repetition by counsel with an attempt to paint him, with a broad and inappropriate brush. There's that great quote that only lawyers and painters can turn black to white. I submit to you that's what we're seeing in this case. Because Judge Ruzumna didn't do anything to violate the canons, especially to the extent argued by counsel. He acknowledges that he made a mistake, that he was entitled to the discount. And who, I'd ask yourselves, just in terms of being reasonable, members of the commission and presiding officer, who would do this? Who would risk their entire career, their family, their livelihood, their future, their reputation for 10% discount? Who would ever do that? All the years of law school, all the years of undergrad, all the years of working up to being a sought after pro tem judge, to the extent to which his whole career is pro tem. And I submit you don't see that very often. The pro tems are so good and so sought after that that's their full-time job. But that's the kind of judge he is. So why would he risk all of that? The answer is he wouldn't, and he didn't. Let's talk about Judge Hirakawa. I think he was such a helpful witness. Not only was he pro tem in King County District Court, but he also is a judge in King County District Court, the West Division. But he's also been presiding over all of the district courts of all of King County. So if there's anybody that's authoritative in this case, it's that judge. He said the following: pro tems are entitled to the discount in the Goat Hill Garage, period. Pro tems work for King County, period. Pro tems are thought to be employees. And he went on to talk about why he says that, because they're excluded from conversation in certain executive meetings because they are employees, and also because of his experience as the presiding judge and as a pro tem judge. Judge O'Toole didn't know. I mean, she can speculate. Judge Robertson wouldn't know necessarily. And all we have on the side of commission counsel is some conflicting evidence that people aren't sure, or speculation as to whether or not a pro tem judge works for the county. But Judge Shiwakawa was very adamant that Judge Ruzumna was entitled to the discount. So why are we here? Let's take a look also at Ms. De Los Santos, and this is it. On the tape, it would be at one of her testimony, 1.36.50 in her testimony. And when she took a picture of the document, I don't really want to call it a document, but of the exhibit that we've seen here, she later determined it was obviously not an official document. So she's in charge of parking at the garage, and she determined it obviously was not an official document. So the claim from disciplinary counsel is that he created an official looking document, and even a layperson could look at it and say it clearly was not an official document. She wasn't misled in any way. And she saw the document with all of the other stamps, not just the partial document that you see here. She saw it with all the stamps. She said it was an official document. Obviously not official document. She wasn't misled. She said also in the same, during her testimony, 1.45.14, she basically said, if there's no ID, there should be another way to show that someone's employed by the county. And there was no judicial letterhead here to gain advantage, anything like that from the judge. Prestige of his office, that's absent. He didn't say, I get to park here because I'm a judge. He said, I work for the county. That's totally different. Those are totally different assertions. In terms of the county and any kind of investigation, there wasn't any. Where there was an investigation, it was in Snohomish County, and they brought him back. So if anything, when you look at other investigations in this case, the investigation that was conducted by Snohomish County cleared him, brought him back as a pro tem. It's very, very important here. They did a full investigation for months. They knew what the allegations were, and they brought him back because he was cleared. But that also goes to the fact that he's been through enough. I mean, he has apologized. He's acknowledged that the appearance issue in this case, and he apologized here. He would never do this again. And I think he said something that really resonated, at least with me. He said, in like the kind of the slings and arrows of our lives, or the difficulty that we all encourage in being human and living, and that sometimes something's was kind of funny to him, or fun, and he just looks back and he can't believe that this is all led to this. I mean, he'd take it back a million times over, and then some. It was just something like wearing the Batman belt that he wears, or saying to the parking attendant, look what I made for you. He had a piece of paper, just like a piece of paper here. We've talked about it, and put a bunch of stamps on it and said, you know, look what I made for you, and would I be able to do this if I wasn't a pro tem? And somehow that's been morphed into saying that he tried to use official stamps to gain an advantage to which he wasn't entitled. He was entitled to. The fact that he was entitled to the benefit, he worked for King County, proves that he didn't create a document in some way to fraudulently induce someone to give him that benefit. He was entitled to it all along. You know, he could have brought in anything with him. He just, as a joke, showed this. And then you go to the Evening Telegraph, where the attendant takes it to Ms. De Los Santos, and then she takes it into HR. And then before you know it, it's gone on and on and on. And even at the time when it went to the CJC and staff, there was still a belief that he didn't work for King County. And that's how something just kept going in this case, even till the beginning of this hearing. That belief that he didn't work for King County. It's amazing but true how something can get on the tracks and just keep going based upon a false assertion or false information. I don't think anybody thought it looked like an official document. And I submit to the commission and the presiding officer, I don't think you think it looks like an official document either, because it doesn't. When you look at the service and demeanor of the judge, we have to look at whether or not he acknowledged or recognized that the acts occurred, and whether he's evidenced an effort to change or modify the conduct. I think we've seen that. I don't know how much more he can say. And it's not just been here and yesterday, it's been for a long, long time, going in person for hours, down to the CJC offices, dealing with counsel, going through this hearing, taking his deposition. He could have said, I don't want to be deposed, as you know the rules. We could have said, objected, and had the presiding officer decide that he not be deposed. But he gladly said, I'll be deposed, and he did it on short notice. He doesn't have anything to hide. And with all of this, all the statements, the deposition, his testimony, being called in the disciplinary counsel's case, don't you think you could find, if he's going to be called a liar, don't you think you'd find somewhere in there a lie? Don't you think you'd find in there some false statement, other than saying he's a liar because he said that he was entitled to the benefit and it was a joke? Those things can't be true at the same time. Well, the fact is they are. It was a joke and he was entitled. Where else is the lie? Because that's what they're asking you to discipline him for. They've shifted from the allegation, they've shifted to a lie. But they've shifted to a lie that doesn't exist. So the next thing on service and demeanor of the judge's length of service as a judge, and it's unblemished. He's served with distinction throughout many courts. I can't name them all. Bothell Municipal, Snohomish County Superior, Ex Parte in King County, the Western District in District Court. And he also could have used a parking pass or a voucher as an ex parte commissioner in King County, but he didn't. So that tells you a lot too. He could have done that, but he didn't use that, even though he has served as a commissioner. He didn't do that to try and get a discount. Going back to the service and demeanor of the judge, on length of service, unblemished, distinguished, and respected. Whether there's been prior disciplinary action, there's been none. None. I think those of you who are judges, you know, it's pretty hard to get through a career as a judge unscathed without somebody making a complaint or a comment on social media or on a live feed or anything else. I mean, judges make decisions. Decisions can make people upset. So to come through without absolutely no discipline, he doesn't have any, and that's a huge consideration under the Deming factors. And for you here, whether he cooperated with the investigation and proceeding. You know, I have defended judges for a long time, going back to the Ritchie case and the Raines case and the Eiler case and this case and many, many cases over the years. Some judges cooperate fully, and then some don't want to cooperate at all, or in a minimum fashion. He has done more than I've ever seen of any judge. Meeting in person, hours, meeting and communicating with the commission before I got involved. Following up and wanting to have a deposition, wanting to be on the phone with disciplinary counsel to try and work through things, a stipulation.
Your Honor, we're getting to 408 territory.
Your Honor,
I tend to agree, at least at that last comment.
all right, thank you, Your Honor. I would just submit, just for the record, that it's not 408 with respect to the meaning of settlement, et cetera, under 408. It's just simply that this goes to his cooperation. It goes to that issue, but I'll move on, Your Honor. Thank you. Over and over and over again, wanting to meet, wanting to talk, wanting to be part of this process, cooperating in a way that, as I stated, I have never seen, and I've defended judges off and on for 30, maybe even 40 years. I don't want to say 40 years, but it is 40 years. The compliance with any relevant ethics advisory committee opinions. There aren't really any here on point. It's an unusual situation. But he did go take an ethics class that Ms. Callner was kind enough to recommend to him. And he actually said he enjoyed it and he learned a lot from it. And he did that quite some time ago without being required to do so. And so you're being asked essentially to remove him, I guess. And I didn't lie. Dearth of evidence, he lied. Didn't violate 1.3. Didn't commit fraud. Didn't do anything that would warrant removal or suspension. Nothing. I mean, I'm almost stymied by it. The first that we saw that kind of request was going to be made was when the trial briefs came out a few weeks ago. Out of thin air, this kind of a request came. And I'd submit to you that it came out of thin air because it came out of no evidence. It wasn't contemplated before for a very, very long time. And you can bet if it was contemplated and realistic, we would have heard that kind of recommendation before, and we never did. So where Ms. De Lozano's agreed, it wasn't immediately obvious that it wasn't an official document. She looked for a few seconds. The fact that she didn't remember a few additional small stamps is not surprising, but remember what she also testified to. She said she did not recall other stamps. So as far as I can tell, what you're hearing from disciplinary counsel is that our client is a quote unquote liar because his testimony is different than Ms. De Lozano's. I guess that's the only remaining argument that we're hearing on quote unquote credibility and dishonesty. She didn't recall. She wasn't sure. How can you take someone that's not sure and then say, the other person says, this is what happened. This person says, I'm not sure what I said, and call this person a liar. I submit to you, can't. You can't do it in the justice system, and you can't do it in real life. Judge Ruzumna has been perfectly consistent, and disciplinary counsel hasn't proved otherwise. as he promised to do. The judge has always maintained that this was a mistake, but that doesn't mean he can't be upset when this was reported to the CJC. He was upset. Of course, in retrospect, there's every reason to be upset, far more so than back when he was upset at the time. Sometimes when I tell people about this case, they're like, "Are you kidding? Why is that a case against you?" But he knows that it's super serious. We ask that you consider that it really isn't anything. He didn't do anything that he intended to be official or deceiving or in any way in violation of the canons. And I submit to you that I think the public looking at this, counsel said, how would you feel having this judge, knowing what you've heard in this case? I think 9 out of 10 on the street would say, why is this a hearing? I mean, he was joking. He showed some stamps and, he showed his robe and he was entitled to the discount and he worked for the county. And, why are we having a hearing like this at taxpayers' expense when that's all that happened? But we acknowledge otherwise. It's important that if there is something like this alleged against a judge, that it be fully considered and that the facts all be dissected and witnesses cross-examined and that the documentary evidence be reviewed. And we appreciate your time and commitment as members of the commission. I know it's voluntary. I know it's can times be frustrating, especially after going through a storm last night and everything else, but that you are very dedicated to serving the public interest and having judges that are competent, that are responsible, that are unblemished in terms of a negative record, and that have been vetted in terms of an evidentiary hearing if there's allegations against a judge. So we appreciate that and we take it to heart what you do, and we appreciate what you do. We'd ask you to dismiss this case though. I think the evidence has been very clear in this case that he didn't violate any of the canons. And the evidence is very clear in this case that he's been honest. And the evidence is very clear in this case that he's actually a great judge and a great person and somebody that's been through a lot and is invested and has cooperated the whole time. And he's somebody that I think we're very proud to represent. And at times he's kind of funny, which he was in this case. And that humor, it looks back at it now and regrets it every day. We'd ask you to dismiss the case. We appreciate your attention. And I won't be able to respond to what we hear in rebuttal, but let me say this. We're very comfortable with how the evidence has come in. We appreciate the presiding judge and your rulings and all of you in the commission. And it's in your hands, and we appreciate all of you. Thank you.
Right. Thank you, Ms. Bremner. Mr. Taylor, rebuttal closing.
Yes, Your Honor, thank you. Why are we here? Why would he risk all of this? You heard that asked repeatedly. Well, Judges O'Toole and Robertson gave you the answer. We're here because he exercised incredibly bad judgment. It's just that simple. That's why we're here. This is not a case about a Batman belt. This is a case about a judge who exercised, in the judgment of others, incredibly bad judgment. That's why we're here. Snohomish County investigation. There wasn't a word about an investigation in Snohomish County that cleared him. He was suspended in Snohomish County.
I object. That's not
Fraud.
The panel members are just reminded to rely upon your memory as to the evidence presented.
Counsel went through the 9 elements of fraud. We don't have to prove fraud. You don't have to decide about fraud. You have to decide, did he violate the code of judicial conduct? That's what this case is about. Ms. De Los Santos, you heard her testimony. She didn't say, well, I'm not sure if there were other stamps on the document. She didn't say anything remotely close to that. Where's the document? The undisputed testimony was that Ms. De Los Santos gave it back to the attendant, and in the ordinary course of business, he would have given it to Judge Ruzumna. Where's the parking attendant? We don't know. They could have tried to find him just as hard as we could have tried to find him, but no one could find him.
Objection misstates the burden of proof. Improper rebuttal.
So as far as the objection, as far as the attendant's absence, I think the evidence is clear that nobody found him, and the burden is on the disciplinary counsel to prove violation by clear, cogent, and convincing. Thanks.
Thank you, Your Honor.
Certainly. And we don't need the parking attendant to prove what Judge Ruzumna did. We all know what he did. I'll finish where counsel began, which is telephone. The document hasn't changed. The stamps didn't change. The only thing that's changed is his story. It's morphed over time. Farcical document into, I put those 2 stamps there to help authenticate the document. So that's the only thing that's changed. Ladies and gentlemen, thank you very much for your time. I appreciate your attention. Thank you, Your Honor.
Thank you to both counsel, and thank you to Judge Ruzumna also. I need to note here that under the commission's rules, all deliberations. Let's see, was somebody trying to say something? Okay, thanks. Just a friendly reminder that all deliberations of the panel in reaching a decision shall be confidential, and the members may not discuss the case with anyone outside of the panel. Any finding of a violation of the rules of the Code of Judicial Conduct shall be based upon, as I mentioned earlier, clear, cogent, and convincing evidence. So when the deliberations are complete under Commission Rule CJC RP 24D as in David, the panel will file a written decision or decisions in an open session of the Commission. The deadline for filing of that decision is within 90 days of the evidentiary hearing or the filing of the transcript, unless the presiding officer extends the time. If personal attendance is required, Judge Ruzumna shall have at least 14 days notice of the announcement. The commission panel's decision is final 14 days after service upon the judge, unless a motion for reconsideration is timely filed as set forth in CJC Rule of Procedure 24E as in Edward. Either party may file a motion for reconsideration. If the decision of the commission is adverse to the judge has the right to appeal de novo to the state Supreme Court. If the decision is to recommend to the state Supreme Court that the judge be removed, then the judge shall be suspended with salary from his judicial position effective upon filing with the Supreme Court, and the suspension remains in effect until a final determination is made by the Supreme Court. The rules also provide under subsection B as in Bravo 7 that, quote, disciplinary counsel and respondent may submit the respective proposed findings, conclusions, and recommendations for discipline, end quote. We have not requested that of either counsel, and I'll discuss that further with the panel as to whether or not they request that. It's not necessary at this point for either party to submit that, but just wanted to give an alert that could be an option. In final comments here, I just want to thank all counsel for your thoughtful, careful, and professional and competent presentations respecting your respective clients. So I appreciate that very much, and it's duly noted, the professionalism and competency. So at this time, we will stand in recess and we will begin our deliberations upon the case. Any final issues or questions from council?
No,
Thank you.
thank you, Your Honor, and thank you to the commission members.
Thank you all very much.
All right, very good. All right, so we will stand in recess. Just a quick kind of technical question. Ms. Kallner, all panel members should remain on the call and then we'll be placed in a breakout room, or we'll just stay on the call and everybody else will exit.